Right, Attorney General Phil Weiser. He'll give a few remarks. We also have members of the legal team coming up and joining. Shannon Stevenson, our Solicitor General. Shannon, everybody come over here, please. You want to stand behind the Attorney General? Okay.
Today the Supreme Court heard arguments in an important case around what is a practice that's harmful, that's banned on a bipartisan basis in Colorado and many other states. It's telling young people that who they are is not okay, leaving lasting harm. This type of pressure, coercion, has been disavowed, discredited by all medical associations. In the United States of America, since the founding, we've had systems to protect patients. There's a fiduciary relationship when a licensed professional subject to malpractice tries to help someone. And it means they need to be doing things that are helpful, not things that are shown to be harmful. The idea that there could be a First Amendment exemption to this is dangerous, can create a lot of mischief. We've made our case to the Supreme Court. We'll now wait on an answer. And if you have a question or two, I'm happy to take one. One of the challenges about this case is the petitioner has put in no evidence into the actual record. If you look at the evidence in the record, it's all put in by the state of Colorado, showing how these practices are harmful. There have been no official proceedings or efforts to take any action against the petitioner. And now, even at the Supreme Court level, they are stating for the first time information that's not in the record, that there's no evidence of, and there's no basis to actually evaluate it. This is not how the Supreme Court should be making decisions. There should be an actual record with facts that have been considered.
Child's team is saying that this is an attempt to censor private conversations. Could you address that and talk about your argument against it?
The long-standing regulation and oversight of medical professionals is treated specially for good reasons. People hold themselves out as professionals who are operating based on a standard of care so the public knows they can trust them. That's very different than private conversations about matters that could be of public or scientific concern. When you're a licensed professional, you have special responsibilities. That's why we have licensing. That's how we have malpractice. This is a very different situation than people sharing their ideas on issues of public concern.
Ms. Child's team said that she's never been asked to affirm a child's gender or sexual orientation. What do you think that says about the kind of services she provides?
I don't know what type of services she provides because we don't have any evidence of what she is exactly doing. And that is a real problem in this case. This has been a little bit of a moving target.
The justices seem open to the argument about strict scrutiny, and I'm wondering what your reaction to that is and how that would impact the Colorado law in your case.
We will see where the Supreme Court chooses to resolve this case and then how to defend our law. Our job, we defend our law to the best of our ability, and whatever the court does, we're going to continue to do that. Thank you all very much.